A probation violation in a DUI case isn't just a slip-up, it's a warning sign. And when alcohol is at the center of the original offense, even one misstep can carry serious consequences.
We have to look at what the underlying offense is. It's operating while intoxicated third.
Mayor said bumps in the road, but there's also consequences when that happens.
This court that Sir Sanders prepared an updated probation violation report dated March 23, 2026. In addition, a number of letters have been submitted to the court, including letters.
She had an opportunity to review the letters of support my client has provided in her statement. My client absolutely respects, Your Honor, respects this court. She still maintains that she did not consume alcohol on November 15th, but she understands the process. She understands that we are here for disposition regardless. Your Honor, except for this incident and a minor incident where my client essentially self-reported, in my opinion, she wouldn't have been probably found to have been in violation of probation, except for the fact that she contacted her probation agent and admitted to consuming alcohol. Ms. Talley has done exceptionally well on probation. She completed sobriety court. In fact, she told me this morning that we were discussing the recommendation that she planned to go to sobriety court graduation on Friday to support other program participants. She's been employed consistently. She was obviously employed on the date of this incident. She's working 2 jobs now. I think, Your Honor, this is a bump in the road and nothing more. She has, don't take this as a challenge, Judge, but I think Danielle has been harder on herself through this process than Your Honor could be. Again, it's not a challenge. Don't take it as such, but I think she, even though there has been this bump in the road, she should be held up as an example of what the sobriety court program can do. I think she has a really good insight into her relationship with alcohol. I think regardless of whatever Your Honor decides today, I think she's going to continue to do very well. I don't think she's going to be back in front of the court again for any matter. Your Honor, I'd ask that the court not impose the recommended jail sentence. Again, she works 2 jobs. She has her children. And I think it's important to note it's now been some 4 months since this violation occurred. Ms. Talley reports that she has not been tested once since the scram monitor came off following the last violation. She reports that she would have been clean had there been any test ordered, but she hasn't been tested since the scram monitor came off following the first violation. She successfully completed that monitoring period otherwise. So, Your Honor, I'd ask that Ms. Talley be permitted to continue on probation without any other sanction. If the court is inclined to order jail time, I'd ask that it be held in advance pending successful completion of probation. What Ms. Talley reports, I think, besides some community service, she's essentially complied otherwise fully with the probation. Thank you.
You're welcome. Ms. Talley, is there anything you'd like to say?
I wrote it.
You did. You did. You wrote twice. Mr. Wallace, anything on behalf of the people?
I reviewed the report, and as this court, there's always those, as Mr. O'Meara said, bumps in the road, but there's also consequences when that happens. This court has found that there was a violation. We concur in the recommendation, and we ask the court to follow it.
Thank you. Well, we had a full probation violation hearing on it. And understandably, for a probation violation hearing, rules of evidence don't apply. So we don't have, for instance, experts coming in talking about this scram device or devices that are used, but the device tested positive for alcohol, and the court found that at the end of the day. The defendant vehemently objected and stated, "I did not consume alcohol." And the court's not saying at the end of the day, that's the end all for this, because
This is a critical moment. Even without expert testimony, the court is rely on the scram device data, and that's often enough in probation hearings, where the rules of evidence are more flexible. The judge isn't just weighing proof, he's weighing risk.
we have to look at what the underlying offense is. It's operating while intoxicated third. So there's a history of substance use disorder relative to alcohol. And consider that. On top of that, the court wasn't aware on November 1st there was a prior violation. Now, according to Mr. O'Mara, that was self-reported. Is that correct? Okay. So, further indication that there's still substance use disorder issues. And the position of the defense has been, hey, look, it must be something wrong with the device or something else that triggered it. She's working at a bar. People came in and testified, well, I didn't see her consume alcohol. Well, I mean, who would? It was a busy night that night. But at the end of the day, the defendant is held to a higher standard. That is to follow through with the conditions of probation. And personally speaking, I think it's a disaster for someone who has substance use disorder to be working in an establishment that serves alcohol when that's the substance in question. But we also have to make a living as well. And the court understands that. And the probation department did everything it could to make sure at the end of the day there was insurance that the defendant would not consume. The court made its finding, and the court stands by its finding. At the end of the day, you look at the behavior and ask oneself, will it happen again? I hope it doesn't. Because if it happens again, guidelines don't apply to probation violations. You can be sentenced to prison. That's how serious substance use disorder can be. It will be the sentence of this court. The scram device ordered for 90 days is ordered, but it's already completed. Outpatient treatment continues. Will be the sentence of this court that the defendant served 15 days in the county jail with 1 day credit. There will be no more excuses. And if I find out, even if it's self-reported, whatever the situation may be, that you're testing.
And there it is, 15 days in jail. Not the harshest sentence, but a clear message. Probation isn't optional, it's conditional. One more violation, and this could escalate fast. So here's the real question. Is this a wake-up call or just another bump in the road?
Positive, don't worry about 14. It's going to be much more than that. The court is also going to order 8 hours of community service to be completed over the balance of the term of probation. And that must be provided, the proof of that, in written form to the probation. Teacher questionnaire form requesting the assignment of counsel from other place of work would be much better. Good luck to you, miss. Don't want to see you again. Off the record. Mr. Mayor, I've got to switch back.